Good evening, everybody. My name is Howard Kaufman. I've been asked to chair tonight's meeting in the absence of Mr. Mosier. Will the clerk please call the roll for the, well, first let me say that it's Thursday, January 25th, 2018, at 5:39 p.m. We're in the North Boardroom. This is the Policy and Procedures Committee meeting.
Okay.
Ms. Raymond, please call the roll.
Thank you. Mr. Kaufman?
Yes.
Oh, my button doesn't seem to be working, so
Here,
I'm going to shout.
try this one.
Okay.
Oh, no, they need you to record.
Okay, so Mr. Kaufman is here, Mrs. Raymond is here, Mrs. Timmons?
So in the absence of Mr. Mosier tonight, those that are here will be voting members. Could you please make note of the other board members that are also here tonight?
Sure. Mrs. Fitzgibbons? Mrs. Williams?
Fitzpatrick.
I apologize. Mrs.
She's an
Dr.
assistant superintendent.
Assistant Superintendent, Dr. Fitzpatrick. We have Board President, Dottie Oden, and Board Clerk, Raymond Guarino, and Board Member, Doris Hohensee.
Okay, thank you. Let me get the agenda. Excuse me. I didn't know I was doing this prior to my arrival, so forgive me. Well, I do know the first thing on our agenda tonight will be the Psychologists Proposal. And I just want to get that information. So this is a proposal that came to the Policy Committee through Mrs. Hohensee, developed the proposal. I know that from, well, I'll just stop there and let Ms. Hohensee bring us up to date on the events that bring us to this meeting, please.
Okay, thank you. We don't have a policy on psychologists in our district, so this would be the first policy that we would have. We spend about $1.7 million on psychologists, so it would be, wise to have some type of guidance for parents for what takes place in the district. If a student has an IEP, they're pretty much understand and sit down and sign an agreement with the district for the psychologist to work with their students on a regular basis. Students who don't have an IEP shouldn't be at any disadvantage. When their children are taken out of the classroom, they too should be notified. And this policy would just simply provide that guidance to parents, the expectation that they will be notified. It doesn't stop the psychologists in any way from doing what they've always been doing. It doesn't change any services they would provide. It just creates a log in those emergency situations where there is no time to contact the parent, and then provides an outline of tracking to make sure within 24 hours or so the parent is eventually notified. So that way no child slips through the cracks. This gives every parent ample notification. And one of the reasons is, there could be a liability to the district if something would happen to a child and the parent wasn't notified and there was some type of relationship with the psychologist. We just want to have something in writing to make sure that the parents are notified, and if not, that an effort to reach them was made. And maybe it says, what time, who they contacted or who they didn't contact. Maybe they got an aunt at the house, but she didn't notify the parent. Somehow this gives us a tracking so that we know what happened to the child if we face some situation like that. It's just basic common sense as I look at it. And I know the school psychologists are comfortable without one and they don't really want one. But I think as a school board member, I think it's our job to provide a little bit of guidance and oversight, not only for the psychologists, but for the parents that come and go in the district so they understand what's happening. I don't believe this is any significant amount of work, because most of the time the child will be notified. It may be even a deterrent for not notifying because they wouldn't want to go through and make a log entry. So it will help them remember that the parent should be notified before the child is taken from the classroom and brought to the school psychologist.
Thank you. So the board members, as best I have in my hand. Very much. A little nervous here for some reason. Us Boy Scouts like to be prepared, and usually you kind of know what you're walking into. So is the policy recommendation titled School Psychologists as submitted by you in the upper right-hand corner?
Yes, and it's a red line copy because there were a few changes I think you requested at a previous meeting.
Yes.
It just gave some clarity to it.
Yes. So what I would like to do is walk through this document and see what comments our board members might have. So we'll just start at the very top. The only change here is the word "and parents." If I don't hear any objection as we go down the document, I'll just keep going ahead with the assumption that there's no questions, clarifications, terminology suggestions. We're all welcome for that. Ms. Raymond?
I do have a question about it says work collaboratively with students and parents. I'm curious about what the intent of what that would look like. So if we're saying that our school psychologists have to work collaboratively with the parents, are we suggesting that that should entail the parents coming in to meet with the school psychologist? Is it something that can be done via phone calls and emails? Or is it something that requires a written plan similar to an IEP? Or is it merely that they let the parent know? I'm just interested to know what that means, I guess.
Ms. Hohensee?
Thank you. I believe this was Mr. Kaufman's change. This is just to get the understanding up front that the school psychologist will be working with students, but it's collaboratively with parents in terms of notification. The list of things that they do would be what they would normally do with a student, but collaboratively in terms of notification. With, if there's any objection, they would obviously step back. Just like with an IUP, you get a parent's approval. They sign an agreement at the beginning of the year. So parents are on board and know what's to be expected, and they're not taken by surprise. It's those, when they're left without notification is when they might get upset.
Anyone else have a question as we go through this? I guess what I'm planning on doing is letting the board go through the document with any feedback that they have, changes they might like to make, and I see that we do have some people here from the special ed department. And once we're finished with this, we'd open it up to comment from you, if that's okay. Thank you. I just want to point out there is a typo on the 1, 2, 3, 4th bullet down. Self-regulation just has an extra space there. Okay. The only other change on this page is permission must be renewed each school year. Page 2.
I have one other question. Do we have a form for written consent?
If we do, it would be permission.
Please.
I would think the psychologists have one for the IEPs. They could produce one for this type of interaction with students.
Okay, so my understanding from reviewing 800 billion IEPs is that they are extremely long, thorough documents, usually multi pages, and many times they include psychological treatment, but I'm thinking about those children who don't have an IEP, where if we're going to ask parents to sign something, we would need a specialized release because we can't have them sign something that's an IEP or a 504 if their child does not meet the criteria for those. So I'm curious if we adopt this policy, does that mean that we also then need to develop a specialized form, or is that something that the school district already has?
Can I jump in? So the way I would respond to that is the board makes policy and the administration implements it. So in the implementation of the policy, if it's deemed we don't have a form for that, I would expect that the administration would create the needed paper trail to accommodate that if they don't already have it in place. And as Ms. Hohensee suggested, it may be as simple as adapting a current existing form for a specific use. But yes, the documentation will follow the policy eventually. Does that answer your question?
Yes.
Okay.
Yes, thank you. I appreciate that.
Ms. Hohensee.
Thank you. I think we have, when you opt out of the statewide assessment, I think we allowed parents to do that by email. So that's considered written consent in terms of an opt-out or an opt-in. They could do something simple as an email to the parent at the parent's current known email address and get a response from the parent. Yes, I think that would be appropriate. I have no objections. It doesn't have to be a form. The department could work that out. But that would be considered written consent because it's written in their email, and we've done it for other policies.
Anything else?
Yeah,
Right now?
I have a list of questions from reading it. Shall I go through my list, or would you like to go paragraph by paragraph?
Well, I would like to get through the document because essentially what we're trying to do is approve a policy and it's what's written. We'll certainly have time to hear your questions and hopefully be able to provide you answers. And if we obviously don't, I hope Ms. Breen and people from the special ed department can help us out with that. So when you get into the world of writing policy, the word shall is my favorite, because why have a policy talk about shoulds or mays or cans? If you're going to write a policy and you want something to happen, the preferred word of legislators is shall. So that's why you'll see this word so visible here. Next paragraph, the addition of the two shalls. Yes, Ms. Raymond.
I do have a concern with the wording of this paragraph, especially bullet number 2. If there is the school child psychologist shall keep the information confidential, but they're required to share information with parents in certain circumstances. Bullet number 2 is there is evidence or disclosure of abuse, physical or sexual, or neglect. It's my understanding that it is against state law to require someone to disclose that they have made a report of abuse or neglect to the Division of Children, Youth, and Families. So if a child were to disclose abuse or neglect of any kind to the school psychologist, it would be violating school law, state law, if we were to require the psychologist to then tell either the parent or the student that they made that report. It might be best practices from a clinical standpoint to share with a patient that you've made a report, but it is protected by law that the people who make reports are protected unless it goes to court and the judge orders that their name be released.
So let me ask you this question. With that in mind, so if a psychologist finds out someone has been abused, is there a requirement to report that to the police if they can't report it to the parent?
Yes, there is a requirement under state law, RSA 169C, that requires them to then make a report to the Division for Children, Youth, and Families, who will then also, they have a policy in place for then sharing that with the police.
So is it your recommendation that this bullet be removed? Or would you suggest a textual change?
I certainly would want to remove that particular bullet. I'm concerned about the language requiring psychologists to disclose information to parents that might be private information that a child has shared with them. I'm not fully versed in what the laws are as far as HIPAA and sharing private psychological treatment information and notes with parents. So I don't have the knowledge to know if we're wading into thorny waters with that. So.
Ms. Hornsey?
Thank you. I think, and I agree with Mrs. Raymond, if the parent would be the person abusing the child, certainly no one wants that to be disclosed. But it could be an uncle, it could be a neighbor. So in those cases, it said in certain circumstances, they would share the information with parents or others. That would be their discretion, and the law would certainly give them guidance on how to notify and how not to notify. But if there's someone that they need to keep the child away from to protect the child, the parent should know it as soon as possible. So there are, it depends how it plays out. There are all sorts of variables in this.
I would just clarify that in cases of abuse or neglect, under state statute, it doesn't say only by mom or dad. If it's Uncle Joe who has been abusing or neglecting these children and the child discloses to the psychologist's requirement is to report to the Division of Children, Youth, and Families first. And the division then shares that information with the parent and makes safety plans. There is a protection for anyone making that report, including psychologists and counselors, that they are not, the law protects their confidentiality, even if it's not the parent. I agree with you that it's best practice. I would hope that they would do that. However, I also know from my personal experience that there are circumstances where the division would ask a reporter not to discuss it with the parent until the division has been able to do, with the police usually, a thorough investigation to make sure that by telling the parent doesn't place the child in further danger. Because we don't know the parent's relationship with this other individual, and we don't know if that would place the child in further danger. So I would just suggest that we kind of stay in our own lane here, let the psychologists work under the mandated reporter law and not put any other undue burden on them that would potentially conflict with that.
Excuse me, Ms. Raymond, what provision of the law, what did you call it? You said let the psychologists operate under the
It's the mandated reporter law.
mandated reporter.
It's RSA 169.
-C.
That's a
Are you finished? I'm finished, thank you. Dr. Mosley?
That's not just for school psychologists, that's just for that's not just a school psychologists that are required on the mandated reporter, that's every single employee. That's teacher, administrator, district-wide. They're required to report any type of physical or any type of abuse or suspected abuse that may be endangering children.
Thank you. Ms. Hornsey.
I just want to put this in context. This is the section on confidentiality. So what we're saying here is the information shall be kept confidential, and then they're talking about those cases in which it might not be. And they are required, it says the psychologist is required to share information with parents or others, that could be DCYS, in certain circumstances, and then there's a list. It doesn't say it's going to notify parents. It says it could be parents or others. I don't think this is binding, and I don't think it's prescriptive that parents are notified in every case. It says this or that. So I certainly agree with you, and I understand your concerns. I don't see this as a threat to those concerns, because this is when confidentiality will be breached, and these are the cases, and it will be breached with notification to the parent or with notification to the department, which is under the others.
Ms. Raymond?
I respectfully disagree. I feel fairly strongly. I I guess I feel very strongly that that we should not be micromanaging these kinds of situations. There are existing laws, and I'm thinking right now of the best practices guidelines. I feel like these things are covered, and we're trying to reinvent the wheel when we don't necessarily have to. And so, for me, I'm cautious about being overly specific in policy language when something less specific can do.
So may I ask a question? If one thing I noticed in this draft is there's no reference to other legal documents. A lot of times we may refer to RSAs that trigger a policy and things like that. So to some extent, I just made a notation for myself that I would like to see the mandated reporter law referenced at the end, at the end typically where we reference these things. So my question to Ms. Hohensee, if we know we're following the law, because we're going to reference the law here, and we'll make reference to the specific 169C here, are you still believe this bullet should be here, or?
If I may answer that, I think it's good to put the reference in there. At the end, we usually do put references to state laws. I think what this section is trying to say, if you read the last sentence, the psychologist shall make the student aware of the limits to confidentiality and inform the student when sharing information with others. If you have a minor or an emancipated child and they're talking to the psychologist, I mean, it's good for them to understand the limits of, if their expectation is total confidentiality, it's good for them to understand that there are limits, either going in, starting out, or wherever they are in the conversation. So I think that was just disclosure, not trying to micromanage, but just to give parents or emancipated children who might read this, high school students, to understand that they can go in there, but not everything there are limits to the confidentiality.
Okay, thank you. Mr. Guarino?
Thank you, Mr. Chairman. You had mentioned that you used the word shall and required. When you use those kind of words, you are micromanaging. So I think Mrs. Raymond is correct.
Okay.
And I think you have to be careful with, with the conflicts with the law, and so I think you have to be very careful with this, because I do believe it's micromanaging. So.
Chair, I've heard that before, and George Farrington's not even here. How did that happen? So let me explain to you what policy is. Policy is establishing things.
I know what policy is.
Please don't interrupt me.
I'm just saying.
Please
what
don't.
The words that you use.
Excuse me. You're out of order. Please do not interrupt me. Okay, you'll certainly have a chance to respond. But policy it's a statement of direction. It's a statement of intent. And words like shall or required are certainly appropriate for policy. Mr. Guarino.
I didn't say they weren't. I didn't say they weren't. I did not say they were not appropriate for policy, but when you use those words, you are directing, they're very specific. That's the point I'm trying to make.
Thank you. Okay, let's just move on. We'll keep that one as an unresolved. Perhaps our guests might be able to, one second, please. Perhaps our guests will be able to fill us in when we get to them. Or maybe I'll just ask Ms. Breen. We'll kind of break a little protocol here. And do you have any specific feedback on this particular phrase that we're talking about? This bullet item on page 2, the second bullet down under confidentiality?
I think that we have.
May I ask that you come forward, please? We need to get you on the microphone. Is that someone's? Jimmy, do you know why we have?
I think it may be Mr. Mosher trying to call in, because when we called him, he didn't pick up.
Okay, thank you. Ms. Breen.
Is this on? I think we have the obligation to follow the law, And what we do is to make the call to DCYF. We don't disclose to children that we're about to do that. We don't, especially if a child is 5 or 6 years old. They don't understand about the confidentiality boundaries. So we always, as a school district, all employees, we don't make 7 phone calls, but we have a discussion. Usually the school psychologist or the principal will call DCYF and make the report.
So specifically to this bullet item, what would be your recommendation?
All of the bullets or the?
No, the second bullet
The
is what we're
second bullet?
speaking about.
It should be called into DCYF.
Can I just interject here?
Excuse me. I just think she has something else to say, that's all.
I don't. I'm
Okay.
answering your questions right now.
Okay, thank you. So what would your recommendation of this text be? That it just be a call to DCYF?
I wouldn't recommend that text in any way. I'm not going to weigh in on that at all at this time.
Now would be a good time.
I don't think calling into DCYF is appropriate.
So you don't think calling to DCYF is appropriate?
I don't think I think calling to DCYF, not calling the parent to inform them, or not letting anybody else know. I think the school district should call DCYF and then step back. The investigation happens quickly, and often they go to the home to investigate, so we're told not to tell parents until the investigation is completed, because the evidence could be covered up and tampered with, and it's not the best interest in the child to tell anybody but DCYF.
So is it your recommendation, or not to put words in your mouth, but so the psychologist is required to share information with DCYF? Is that what you would recommend here?
I would follow the law, the recommended law for reporting.
Under the confidentiality section?
I'm not talking to the document. Doris created that. I don't know where it would go. That doesn't really matter. The state law should be followed.
There's nobody here objecting or suggesting that state law should not be followed. Okay, so please don't suggest that someone's suggesting that, okay? There's a proposal here.
Yes.
It's valid, it's before the committee, it's being discussed. I've kind of brought you in because I want your expertise, right? So confidentiality should be subject to the law?
I guess that would be an appropriate place to talk about that topic, yes.
Okay, but here's my concern about a policy. I would say that the staff of the school district is very well versed in this mandated reporter law and understands it very, very well. To a lay person, a parent at home who might be experiencing problems with a child, and all of a sudden they find themselves, oh, they're talking to the school psychologist, and I need to find out more about. This is informative to parents. If the first time they hear about the state law may very well be at the end of our particular policy. So I think we have a responsibility to inform parents and refer them to the law as appropriate. And I agree that the law itself is the final arbiter of fact or whatever. So I'm trying to get your recommendation here. Are you suggesting that just the school psychologists are required to share the information with DCYF per, state guidelines, or we can refer to the mandated reporter law? Is that what you would suggest here?
If you were going to have a policy, that would be the protocol for parents, for school district to call DCYF. That would be the appropriate thing to do.
Okay, thank you. See, Dr. Mosley, I know.
I don't want to speak for Chris, but this proposal contradicts many laws that are on the books. And so I want to just be very clear. This is very difficult to accept. So my recommendation to the policy committee is not to create your own policy, but in fact just follow state mandates and let the school psychologists and educators just do what they do. So my recommendation would be not to accept this current policy that's being proposed, but instead just follow what what has been proposed already in terms of following the law.
I'm sorry, Dr. Moser, when you say proposed in terms of following the law, the board currently, to the best of my understanding, does not have a policy in this realm. And it's felt, at least by Ms. Hohensee, that we feel we should have something. So in the absence of a replacement, I think we certainly deserve to hear the policy that's been proposed. We give respect to our board members and community who may in fact make a policy proposal, and we want to hear the benefits, pros and cons. Eventually there'll be a vote by this particular body and eventually to the Board of Ed, as you know. So we're process rats here. We go through this process. We micromanage the words on this piece of paper because that's what we do. I'm sorry, Ms. Timmons, did you have your hand up before?
Yes, I do agree with Mrs. Raymond and Dr. Mosley. We're wasting our time. And this is a form of micromanaging, and we should get on with it. We already read the policy. We should vote on it.
I'm sorry, Ms. Raymond. We have not, Ms. Timmons, I'm sorry. We have not finished going through the policy. And due respect to the board member who proposed it, I think we should go through it like I would expect us, just like we did a curriculum the other night. We were presented with a document and we showed respect and we went through every word because that's what we do. So I'm going to continue with the document.
You may continue.
Thank you.
But we read the document, and we know what's on the document, and it's just a waste of time. It's already 10 after 6, and we could get to the motion of approving it or not approving it. If you want to go through this whole document for the public, I agree to go through the document.
Are you making a motion?
I'm making a motion not to accept this policy.
Okay, that's not a motion, I'm sorry. We'll just continue.
Yeah.
There's a format to a motion, and that's not an appropriate motion to make.
Okay.
Please use the appropriate
You
terminology.
can tell me
if
the
you-
exact terminology, and then I will use it not to accept this policy.
Right now, we're going to continue with the review of this
So
document.
it doesn't really matter.
When you come up with the motion, it will matter. She'll get it right. Actually not. Go get your books, folks. So let's continue with this, please. Rights to file access. So again, the request is that session dates be added as well as records be stored safely and securely. And a parent has a right to access their child's file and visit with the school psychologist to discuss, review, or copy the contents of the entire file, of the file. Is there any problem with that? Ms. Raymond?
I don't have a thorough working knowledge of confidentiality laws when they apply to children in mental health treatment. So I'm questioning whether or not there are any laws surrounding parents' ability to have copies of notes. I certainly would be concerned about RSA 169C coming into play again, where there is some confidentiality if there are any discussions of abuse or neglect. So for me, this section, I don't know what I don't know, and so it concerns me. So if anybody has information on that, I would appreciate hearing that.
Ms. Raymond,
information.
you just said something which I think is at the core of the whole situation, is that you don't, and I'm with you on this, I'm not criticizing you in any way. We don't know what we don't know. Yeah. We know that there's no policy around the actions and work of our psychologists, and I think intuitively we know that there should be, okay? And that's the purpose, that's why we got here. So to that extent, I think we need to do something. Ms. Timmons?
We don't have a policy, but yet you want to half-baked policy. So I, again, make the motion not to accept this policy and go
Excuse me.
back to the table again and to work something out that's feasible. and more common sense.
So are you moving to place this on the table for future consideration?
No, I'm moving it to remove the policy altogether, not for any consideration.
Mr. Raymond? I'm sorry, Ray.
That's okay. Guarino, that's all right.
No, well, Ray,
That's
Raymond,
all right.
that's where I
That's
got
okay.
there, sorry.
You have best practices that were attached to your information. So as far as the policy goes, you say, you just made a conclusion that we need a policy. We don't really. We have best practices, and they've been getting along without it, and they have the law to follow. So I just
Okay,
wanted to make
so
that point.
May I comment on your comment? It's my understanding that this best practice document is a newly created document. It didn't exist prior to Ms. Hohensy's proposal around this whole topic. So this has not been in effect because it hadn't existed prior to this discussion at all. So this document is, in its own words, by its email that came with it, is a suggestion. It's essentially, I viewed it as a draft of a document. So are you suggesting that this best practice document be incorporated into our policy or refer to the policy, Mr. Guarino?
No, I'm telling you, they already have something that they can follow there, which they don't really need the policies. They have the best practices.
Okay,
And I'm
so
sure they got
hear what I
industry,
said.
I'm sure, I'm not finished. I'm sure they got industry standards. They just didn't make this up out of whole cloth. I'm sure they were following industry standards as people do, as professionals do.
Thank you. Please give us your name, please.
My name is Mark Lecare. I'm the chief school psychologist in the Nashua district. What this conversation, I think, reveals is that one of the many problems with this proposed policy is that it treads all over existing laws that have to do with confidentiality, privacy, mental health practice. And there are many laws in this area, federal laws, state laws, HIPAA, FERPA. You would need to be a lawyer to write the kind of policy that you're trying to write. And we're not lawyers. Also, the guidelines that are provided were provided as an attempt by the school psychologist to educate board members about what school psychology is and how school psychologists operate. And the fact is that the National Association of School Psychologists, which is our national professional association, already has all kinds of documents that guide the work that we do in schools. These are documents that are published, that have been researched, and that are accepted as standards of practice in our field. And that's what we need to use to guide our work, not this policy. This policy is flawed, it's not practical, it's overreaching, it's obstructive, it will impact the work that we do with kids. It's not good policy, and it should not go forward.
Thank you. Ms. Hohensee?
Thank you. We're not lawyers, but it is our task as a board to write policy, to oversee the district. Whatever we need to do, whether we need to pass it by an attorney, we've done that in the past. To Mr. Guarino's question, we have things called best practices in recess before lunch. We were given those, and we created a policy that referred to them. So just because there are best practices doesn't mean that we don't incorporate some of those in our policy. That has been past precedent. If we don't address this, we expose the district to a lawsuit. Parents are not happy when their child is pulled out of classroom and they aren't given the respect of a notification. Now, the confusion over this confidentiality thing is key to why we need this policy. This wasn't prescriptive, saying the psychologist must tell the parent. This is the scope of the confidentiality, to let the student or the parent understand you just can't come in there and talk about things and don't think there's any consequence. If you're threatening someone, there are limits to confidentiality, so they know in advance that they can't just go into a confessor, give this information and walk out cleansed. There are consequences to what they say. There are limits to confidentiality. I sat down with Mrs. Bream and Mr. Leclerc, and I tried to work through this policy. Their opinion from the get-go was, we don't need this. Now, I'd be happy to go back and sit down with them and make a policy that adjusts to these topics to inform the parents and to ensure the fact that parents are respected and they're told when their child is pulled out of classroom. It's not just that they're losing academic time, it's they are concerned why their child is being pulled out. And if they're not being disrespected and they're not being told, then they call a board member, and I look around and don't see a policy. I sought answers from the administration last year, from the psychology department, from the pulpit, so to speak, in public, two or three meetings. I got no feedback. So I turned around and did the best thing I could do, was I went online, I researched it, I drafted a policy. I'm happy to sit down and work with anybody who's serious to accomplish this end and make modifications so that we don't step on laws. But just because there's laws doesn't mean we don't make policies. There's many policies that we make that respect the law, that incorporate the law. So I'm not trying to change their job description. I'm trying to ensure that parents without IEPs are respected. And if you can find a better way to do that, I'm all in.
I'd like to ask Mr. Leclerc, I got you, hold on a second. May I ask you a question? Could you please come forward again? Thank you for coming tonight. So you made mention of your professional organization and all the research and things that they do. Do they have anything, to Mrs. Hohensy's point, of I'm just going to call it a model policy that you said they do a lot of work with school districts, they give you guidelines, so along that line of what you had said, does your professional organization provide a school board type policy around this topic that we could use as certainly a template, or may even adopt it as it is, certainly that we can discuss?
Now, I am not aware that they offer any kind of sort of template for a school district policy.
Is that something you can inquire upon for a future meeting?
You know, you can. I mean, I really.
Actually, you're the expert. You have hooks into the organization.
Well, thank you.
I do not. You're a professional member of that association. That should be a service I would think they would provide to their members if requested.
Well, I appreciate you recognizing my expertise, but I think I've already made very clear where we stand, where I stand, and where the school psychology department stands. We do not believe that this ought to be made into a policy. We just don't agree with it.
Okay, so let's say I agreed with you that this text, as presented, should not be made into a policy. But what I am asking for is replacement text, because I agree with Ms. Hohensee that there's a need for such a policy. So I'm looking to you as experts in the field to be the source and go to your professional organization. If you're willing to accept their ethical guidelines, which I personally found offensive, where they suggested, see if I can find it, that the psychologist didn't have to advise a parent in the event of an emergency, that was somehow ethical. So please, I'm giving your organization opportunity to shine here and provide us with a source that perhaps that I would at least presume that you as professional psychologists would approve of. So I'm asking you to provide that. I'm certainly, Ms. Hohensee expressed her desire to work with you to produce such a document. So I'm asking for your help. Is that something you can do? And we can certainly table this for a future meeting, subject to the receipt of that documentation. You gave us all this other documentation.
Sure,
but none
sure.
of it is policy. So I'm only asking
Right.
if your organization has a
I'm
policy.
I'm not a policy writer. I'm a
I didn't
psychologist.
ask you, I asked you if your organization had a policy.
Yeah. I think you keep asking me the same question, and
I know,
I think I
it gets
made.
frustrating, doesn't it?
Well, I made
If
my
you don't
point really
answer, you
clear.
get the same question. How many times does someone have to answer
Okay.
a question before
Then
they
the
get an answer?
answer is no.
Thank you.
No, I
So
won't
you
do
do not want us to use, if your organization had such a policy, you'd recommend against using it? Because I will go out and do
Is that
research.
I'm not aware that there is a policy. I'm not interested in writing a policy, and I don't think that the school district needs a policy.
Okay, thank you, Mr. Guarino.
Yes, I can help you because Ms. Hohensee asked me if I can come up with something better. Yes, a one-sentence policy that in such incidents that when you do have these emergency crises, that the parent is notified. That's all you need to do. If that is what the problem is, then all you need is one sentence. That's all you need. You don't need a big, and then you can get the administration, you get the Mr. Lacier's recommendation. How would the psychologists notify the parents after they've complied with the law? In an emergency situation, they would that the school department would contact the parents. One sentence, that's all you need.
Thank you, Mr. Guarino.
Yeah, well, I appreciate that. It's just not that simple, because then you'd have to define what's an emergency. And if you can't define that in a very clear way, then there's a whole lot of judgment that's involved in that. And that's the problem around trying to write a policy around things that it presumes that things are always black and white, and mostly they're not. They're mostly gray. Most of what we deal with are very gray situations where our clinical judgment comes into play. And so it's and as much as you'd like to make it simple, it's not that simple.
Do you have something? Ms. Raymond?
So as I'm listening to everybody, it seems to me that Mrs. Hohensee wants to make sure that our district is being respectful of parents' rights. Is that, I don't want to put words in your mouth, but that's the impression that I'm getting. And I'm wondering, is there evidence that we're, as a district, having difficulty with this? Or is it, have there been specific situations where we've messed up, where we should maybe talk to HR about personnel issues instead of having a wide-ranging policy? I'm just curious about if there's a way that we can address that very real issue without something so contentious, if it is in fact an issue that we're kind of messing up on. So.
Did you want to speak to that?
Certainly. I mean, this came about because one of our elementary school's children was taken from the classroom over an issue that the parent was, there's a difference between an emergency that there's no time to contact the parent. After the emergency is done, then there will be contact time. But this was not an emergency situation. There was all the time in the world to contact the parent prior to pulling the child from the classroom, and no effort was made to do so. No effort was made after the fact. No effort was made despite my coming to the board and asking the superintendent, the department, asking anybody I could. I got no answer. So I just want a guideline. So I don't want to blame anybody for the past. I just want a guideline, a policy, so that we can work constructively going forward. If this needs to be adjusted, that's fine. But I know that there's always informed consent for the IEPs. There's always written consent. So why do they get more protection than a student that doesn't have an IEP? So I want equity.
Ms. Timmons?
The IEP, you can't compare it with anything else because they do get funds from the state. So that's one reason. The funds are from the state, and there's for specific reasons that the funds come into the school. So it's different that way. However, we went through this before, and if one parent complained about it and then you didn't disclose who that parent was, how do we know you're telling the truth? So
Sorry, Ms.
that's none of
Timmons,
the
please
same.
don't do that.
Well,
That's out of order.
I'm just saying, it might be
I
out of order.
would request apology on Ms.
I'm not
Hohen's part.
apologizing, I'm sorry, but
I'm going to
like
ask you to
move-
stop speaking then.
Oh, I don't think you can do that.
Well, I tried. But you are out of order if you're going to be disrespectful to another member.
I know, the disrespect did not come from me, thank you. But as I said before, we did hear this before. We did not hear what it was always a parent. We cannot change policies for one parent or one situation, but I don't need evidence to back up what that person said. Ms. Hennessy said at that particular meeting that I was there that because she couldn't reveal it because of retaliation. Those are cop-outs to me. And I think that we do not need to micromanage this department. They've been doing this before Ms. O'Hannessy came in on the board, and also myself that came in on the board. If you can call me inexperienced, that's fine. I know what I know. And I know this policy is not good for us, our students, not on one incident. Thank you.
Okay. So, may I ask Ms. Raymond, you seem to be somebody who's very close, having professional experience working. So how is this dealt with? My problem is, I share the problem that Ms. Hohensee describes, is why wouldn't all parents be equally notified, regardless of IEP or not, if their child was somehow involved in an emergency or a situation that took them out of class? And I don't understand why in one case, I don't understand the difference, okay? If someone has an accident, we go to the hospital, the parents are notified, that happens immediately. To Ms. Hohensee's point is equity. Why should notification of a parent be different in the case of an IEP or 504 than any other parent? That, I think, is, for me, the core question. Mr. Guarino.
Yeah, I have a question. Was that case that you cited, was that an emergency or not an emergency?
It was not an emergency.
It was not an emergency. So then why are we discussing whether parents should be notified in an emergency or not? Because that was not an emergency. So it gets very convoluted, and you know, this is an anonymous parent and things that happen. So we don't really have a lot of evidence here to go by. So,
Ms. Raymond.
Thank you. I believe the chair had asked me a question, and I have a couple of things. I think we're kind of getting lost in the weeds a little bit, but there are circumstances, in my experience as a social worker, where kids are pulled out of class all the time for lots of different reasons. My own children will come home and tell me that the guidance counselor pulled them out to play basketball in the middle of a Friday afternoon as like a reward because they were doing well, or pulled them out in a group to have lunch or to talk about something. These are not things that the school has ever called me about, and not things that I'm particularly concerned about because it's in providing services to treat their whole selves, their well-being as well as their academic selves. Having said that, I appreciate, as a parent and as a community member, concerns about parents not knowing what's going on with their kids. I don't know if I'm going to make a motion or not, but I feel like this particular policy and then the best practice guidelines that we got might need some consultation with an attorney or someone who knows more about the law than I do, so that we make sure that that we're following, Ed 30625, but that we're also following any laws that are out there protecting confidentiality that I don't know about. I simply don't know. And I'm worried about us wading into waters that we don't understand. So at this point, that's where I'm at. So.
Ms. Hohensee?
I'd be happy to take this offline and bring this to Attorney Bolton. I think he would be the person to ask and come back with a revised policy or proposal if he believes one is possible, if there aren't too many laws that get in the way. ED 306.25 says psychologists are optional, and if they are, then they follow the APA guidelines versus.
Right.
Okay, there's not a lot of definition in there, and I think we understand that we want to notify parents. I think we agree with that. The reason we have to do it for the IEPs is we're getting federal money. So when you get money, there are strings. So we're required to do that. So these other students, they don't get the federal money, and there are no strings. But I think we want to do better. We want to, come up with something that we respect parents, and saying there's consent, and saying that it can be by email, a quick note, a quick call, somehow giving a structure to what happens so parents feel comfortable. This parent doesn't feel comfortable. This parent's concerned it could happen again. The child is young. She's in primary grades. So how does she say, no, I don't really want to go and talk, or I do want? I mean, she's at their beck. She's more vulnerable. So I think that parents would like this, to know what the structure of what goes on, what the expectation is, and are they met? And that way she would maybe feel better coming forward. Right now, she's just at a loss, especially since there was no response when the inquiries were made.
So, yes, Ms. Raymond.
Sorry, I'm probably out of order here. So I guess for me, there's two separate issues here. One is ongoing psychological treatment with the treatment plan, which to me is more in line with like something that you're getting through an IEP or an IEP thing. And a second thing would be a child is having a rough day at school, is crying, is upset, and the school psychologist checks in on them. And maybe she had a fight with her best friend. I don't know, or maybe there's something really traumatic going on in their lives. But I certainly want to make sure that whatever we decide to do, that we don't impede our staff's ability to do what they need to do if there's a child in distress at school. I'm concerned about a parent, especially. I'm concerned about a parent being able to blanket say, no, even if my child is having a terrible day and they're crying and unable to participate in class, I don't want them to talk to the school psychologist without me knowing, being there, something. So I just want to make sure that we are very careful with what we decide to do, because I think parents have rights, but we also have to trust our staff to be able to react quickly to whatever situation there is. And sometimes there might not be time to call mom and ask, hey, do you mind if I talk to your child about the fact that they're having a distressing moment? So
Ms. Timmons?
Yes, I think we shouldn't be overreaching, and I think that this policy is overreaching. I think we should allow our school to do their job. I think they've been doing a wonderful job in all these years, and to overreach is doing a disservice. That's my opinion.
So I'd be willing to move to put this on the table.
yeah, I would second that.
Thank you. All in favor? Or any more discussion, I should say? Ms. Oden?
Thank you. I heard the professional that we have leading our psychologist say he sees no need for this. I respect his professional judgment. I respect our professionals that are working with our children. I'm very bothered in the fact that Ms. O'Hensey has said she took some time from them, would like to take more time to develop a policy that they're not interested in. They don't think it's necessary. Those psychologists and these people here need to be working with our kids. That's why they're here. And to take time away from them, I think is wrong, and I think it's cheating our kids. I don't see a need for this. They're the professionals We pay them for their professional opinion. I'm looking at the first page of this. Written consent required. For students under the age of 18, written consent from the student's parent or legal guardian is required. My understanding is that age limit varies from state to state. 18 years old, when students are that old, that they can get in big trouble if they go to the psychologist and the psychologist calls the parent for consent, and the kid goes home and the kid is in a whole lot of trouble. You're not going to get kids seeing the psychologist. And we know that our kids need that. We heard that last year when the kids from Clearway came here. So I'm not going to support this policy. It's something that our psychologists, our professionals, say they do not need. I know they have professional standards and professional ethics, and I believe they follow them. So I would hope that we would spend our time on other issues. Thank you.
Okay, the motion, any other comment? Dr. Mosley?
I concur what Ms. Oden has said. This policy has plagued the school psychologist department for about 6 months. And they've spent more time getting documents gathered for this presentation, spent more time worrying about their positions and jobs than they should. And the fact that we're here again, it's going to be tabled again, that only means that they're going to be back here again, away from their families, back here again, trying to justify something that is unnecessary for our kids, unnecessary for us to be talking about. The fact that we're doing this again and again only reinforces the fact that our public and our kids deserve better than this. We need to start to move in a direction where it's productive time, move in a direction where we're following our own state laws and requirements in a way that's the best interest of kids. I asked the policy committee to vote this. No administrator in this district supports any of these policies that are being presented here tonight in terms of this psychology policy. But more importantly, if any parent that has a concern about something, I ask you to come and report it directly to an administrator or someone within the school district and work with us in that partnership. We never want to ever have a student to be placed in any way danger or placed in a way where they don't feel comfortable reporting that. Once we get that report, we will follow state law and guidelines, and we do not need to reinvent the wheel. More importantly, and this is something that, as I sit here, I want to say to the public that we are better than this. We respect each other. Even when we have disagreements, we don't censor each other. We listen to each other, and this is what we will move forward in doing. I ask that the board, in this particular case, make sure that we follow that lines of communication, and certainly even if we disagree with what is said, we still understand each other and treat each other with respect.
Any other comments before we vote? Ms. Hines?
Okay. I thought the understanding was that I would take this for a legal review, not to plague the department again, and maybe streamline it to come up with a simple policy that would be beneficial to parents. Parents have children too. Parents are important. They are why we are here, and I just wanted to have it looked at by different eyes.
Thank you. Anything else? Ms. Timmons?
I want to make sure I get this correct. I move that we question.
There is a motion on the floor.
Okay, and can I move that question off the floor, or how does that work?
No, we're going to have a vote on it
Okay, we'll
first.
vote on it, okay.
So generally, we have a motion, then it's seconded, then we open it for discussion, which is what this was, and then we vote on that.
Okay.
And that's where I was trying to get to. Mr. Guarino,
What is the motion?
I was going to repeat it before.
Okay, thank you.
Yes, the motion is to table this discussion.
Okay.
So all in favor? Aye. Aye. I'm voting aye in favor.
Point of order,
So there's only-
there are 3 members of the committee. 1, 2, and 3, three voting
Yes.
members.
Those are the only voting members here tonight.
Yes, sir.
Three of us here.
Yes.
Right, so we're voting on whether or not to table it
Yes.
and have it come back again for discussion, yes?
Well, if it comes off the table, right now, what we're doing is we can put it on the table.
Got
It
it.
has to be picked up
Okay.
later on.
All right, so
I'm voting
Mr.
yes.
Kaufman votes yes, I vote no.
And I vote no.
Okay, motion fails 2-1. Or I should say 1-2. Okay. Given the time where it's only, we only have 15 minutes left tonight, what I would like to do is try and be a little bit of expeditious in the time, and, sorry. So on the agenda tonight, I'd like to move, 1 second, please.
Okay.
What I would like to do is bring up policy JRA, which has been to the committee before and received some minor modification, and I think we can get that done tonight before we close at 7 o'clock, because we have another meeting with Mr. Bolton. Ms. Timmons, did you have a question?
Yes, I move to postpone the question indefinitely.
We've already voted.
We tabled it, we voted to table, right?
Not to table it.
Not to table it.
Okay, there's a motion on the table to suspend indefinitely.
I'll second it.
Ms. Raymond seconds. Any discussion? So is it your intent to postpone this indefinitely and never discuss this matter again?
Yes.
Okay, thank you. All in favor?
Aye.
Aye.
Opposed? Me. Motion passes 2-1. Okay. So I'd like to bring forward policy JRA, access to student records.
Mr. Kaufman, I can speak to this.
Ms. Fitzpatrick.
On page 10 of 12, the change that was made was under the disclosure of student records and student information. At the full board meeting, there was a concern about specifically number 5 and when organizations are conducting studies. So you will see in red, what was added was with superintendent approval, organizations conducting certain studies. Because if you look at the other numbers under student records, it's things like colleges wanting transcripts, the courts, accrediting organizations. If we had every single thing, 1 through 8, go across the superintendent's desk, we would have a bottleneck that would never be opened. So the specific concern at the full board meeting was the conducting of surveys. And so this makes it so that any survey or group that wants to do a survey must do the survey with superintendent approval. Other than that, these other pieces are more matter of business or above our ability to say, no, we can't tell the court, we can't give them information. That's the only change.
Thank you. I would entertain a motion to approve policy proposal JRA as amended. Do I have a second?
I'll second it.
Thank you. Any additional discussion? All in favor? Aye. Opposed? None. Motion passes 3-0. Given the hour, I'm going to accept a motion to adjourn. May I have a second, please?
Excuse me, Mr. Chair, we have 2 more policies in 15 minutes.
Well, it's about 12 minutes, and I certainly believe that those policies deserve and will require much more time than 10 minutes to discuss and vote on, so I'm not prepared to bring them forward tonight. Thank you. I will entertain a motion to adjourn.
I wonder if we could at least look at one of them in the 12 minutes.
You're
that
not
we
going to
have.
get them done, and I think it would be, if Mr. Mosier's here the next time, I think he should be part of the discussion to start it from the beginning. I just think we would start something, and in 5 or 10 minutes, we'd be stopping, because we don't have the ability to extend or even complete would have been a 2-hour meeting. We didn't, this was scheduled as a 1.5-hour meeting, and another meeting bumped up against us at 7 o'clock. So perhaps had we had our full 2 hours, we certainly would have had time to dive into it. But I think just to run a meeting and start something knowing it's going to stop in 10 minutes in an incomplete state, I don't think is a good idea. So that's why I'm not bringing it forward. So I'll entertain a motion to adjourn. Well, I'm sorry. I'll tell you what, let's see if we can make good use of our time here. I apologize. I forgot. We have these other maintenance type things that really don't require a lot of discussion that can be addressed. I'm sorry, I'm so disorganized by this paper tonight. So JLCK, Special Physical Health Needs of Students.
That's next month.
Oh, I'm sorry. Okay, so, I'm sorry, no, I misspoke. So I'm gonna stay with my decision to accept a motion to adjourn. Ms. Raymond.
One thing, if you don't mind, Mr. Chair, is I did want to make a motion regarding the start time of this meeting.
Oh, yes, thank you.
If you are still willing to entertain a
Absolutely.
change. So I would like to request feedback on changing the start time to 6 or 6:30. For myself, getting here for 5:30 is really hard. So 6 or 6:30, if that works for the other members, would be extraordinarily helpful to me.
So if I may just try and help you out. So motion to change the starting time for the policy committee meetings to 6 or 6:30. Move to make them for 6:30 p.m. Can I get a second, please?
Well, I'll second that.
Okay, and may we have any discussion?
Discussion. I think we should go at 6 because we have to be mindful of the other people as well. So moving it up a half an hour, I think, would be better than moving it down up to 6:30. 6 o'clock would be more feasible for people to have to come here and have to get to work the next day as well. So my 6 o'clock would be better. I can do 6:30, but I'm thinking of other people's time as well.
Mrs. Oden?
Yes, I saw an email from Ms. Van Twyger that said their meeting, curriculum evaluation, would start at 6, and I don't remember them taking a vote, but I think you might want to leave some flexibility in there occasionally because of weather or something comes up. You might want to make it at 6:30, so I think somehow you should leave yourself a little bit of flexibility in there, should you not be able to start at 6 for some reason.
Well, if I may, and I did see your hand, Dr. Mosley. So we are a public meeting, so we have to notice and we have to publish a particular time. So like tonight, we may have started 10 minutes late because of the AV, but generally we would start at whatever that prescribed time is. So is it your recommendation that we go with 6:30? As it might, to your point, it's a little more flexible.
No, what I'm saying is, you've said we start at 6. You should maybe have a word in there. We will try to have all our meetings at 6 o'clock when possible. But if you have to change a meeting, just know that you should have that flexibility.
Okay, thank you. Dr. Mosley?
Maybe a recommendation would be to make a motion to start the policy meetings after 6. And so that allows you the flexibility that Ms. Odom is talking about. So you can start it at 6:15 or 6 o'clock. It just, maybe it provides you some of that flexibility.
Like I just said, we're a public meeting, we have to start at a particular time. That's our commitment to the public. I don't think you could notice a meeting and say, we'll start it after 6. So is that 6:02 or 6:20? Just something, I have a problem with that. Mr. Bolton, you're here, you shouldn't have come early, I guess. Could you weigh in, please?
Yeah, I think this is not that difficult, frankly. You could say, unless otherwise noticed, the regular starting time for the Policies Committee will be at 6 p.m. And then if there's some reason to notice the meeting for 6:30 or 7 or Saturday at 10 o'clock in the morning or whatever, you've left yourself that flexibility.
Okay, thank you, Mr. Bolton. So, having made the original motion, I withdraw my motion. Ms. Raymond, would you be inclined to withdraw your second?
Withdrawn.
Thank you. So allow me to make a new motion. I move that,
I wrote it down if you would like.
oh, you did? What have you got?
Okay, so I will make the new motion.
Thank you.
Unless otherwise noticed, the regular starting time for policy meetings will be 6 p.m.
Second.
Great.
Any additional discussion? Shall we have a vote? All in favor?
Aye.
Aye. Opposed? None. Motion carries 3-0. Thank you. Thanks, Ms. Raymond, for reminding me.
Thank you. So as it is now 5 of 7, I will give you your motion to adjourn.
Thank you. Is there a second?
Second it.
Ms. Timmons, second. Any discussion? All in favor, say aye. Aye. Any opposed? None opposed. Motion passes. We are adjourned at 6:55 p.m.